have, what is it, 4:01?
Yes, we do.
No, it's
I have
exactly
4.
4 o'clock. It's exactly 4 o'clock. Okay, great. All right. Hello and welcome everyone, and thank you so much for sharing your day with us. We are so excited to have you join us as we kick off on our 7th annual Pikes Peak Area Agency on Aging and End Credit Union Retirement Series. This year it's going to be just a little bit different. We have added another session, so we have 5 sessions this year. Hopefully you saw that when you registered for today. And we expanded our bandwidth to the state of Colorado. So we are hoping to reach many more people in the state, and you will see that your handouts will reflect that relative to this presentation today. My name is Pamela Hogard, and I represent the Area Agency on Aging. And we also have Jessica McMillan, who is in behind the scenes, making sure that the webinar runs smoothly today. So she is responsible for the IT part as well. You're probably already familiar with the Area Agency on Aging, but as a quick reminder, we specialize in providing senior information, resources, assistance, and public education for adults 60 and over. And in particular, we are privileged to house the local state health insurance program that provides objective Medicare and health information. So there's a few housekeeping things we'd like to mention to you. Please make sure your microphone is on mute. And I will let Bree talk a little bit more about the the prize that's associated with the surveys. You will have a survey at the end of this webinar. It'll probably come out tomorrow morning. But anyone who completes a survey will have a chance, their name will be put in a drawing for a $50 Amazon gift card for each session. So let's just figure, do the math. If there's 5 sessions, well, you know what I'm saying. So at any rate, what I'd like to do at this point is to introduce our partner and credit union. And I'd like to introduce Bree Shalito, who is the manager of community education. And she'll say a few words about End Credit Union and their partnership with us. Bree?
Thank you so much, Pamela. Yes, as Pamela said, this is our 7th year partnering for this series, and we're very excited to extend that out to all of Colorado. So thank you so much for being here. Through this partnership, we're able to get out vital information about retirement, not only to those who are currently going through the process of retirement, but we're hoping to those who ever are considering retiring throughout their lifetime. As Pamela said, I work for End Credit Union. I work in the community education department, which is very pleased to partner with the Pikes Peak Area Agency on Aging to offer this series and also offer other courses in our communities just to better the lives of Colorado. At Ent, we have been around for over 60 years. We've got over 40 convenient locations across Colorado, and we just love serving this community in any capacity that we can. Our mission is to improve the financial lives of Coloradans, and we hope that through this series, we're able to do that. As Pamela mentioned, we certainly do have that giveaway here for the people who actually participate in that survey. So we really appreciate you being here. And even though it's our 7th year doing it, we're always open to feedback. So please do that survey. And if you're interested in entering into the prize drawing of the $50 Amazon gift card, we would ask that you include your information so we know who that winner is. But if not, the surveys are also able to be anonymous. So we'll leave that up to you. And if you'd like to enter, certainly put your name. But thank you so much for partnering with us. I'll give it back to Pamela to introduce our speaker.
Very good. Thank you, Bree. We are honored to have with us again this year the prestigious Skip Morgan of Morgan Law Offices. He specializes in wills, trusts, estate planning, probate litigation, protective proceedings, and military law. And he did want me to mention that he has won the Nobel Prize in Physics. He wanted to make sure that you know that this year. So, okay, I did it, Skip. So without further ado, I'd like to introduce Skip Morgan, and we will have the questions. I'm sure there'll be questions, so put them in the chat, and he's going to play it by ear depending on how the session goes in terms of length. If it's a general question that pertains to everyone, we can probably answer that as we go. But he will make the final decision on that. So Skip, it's all yours.
Thank you, Pamela. And no, I didn't win the Nobel Prize in Physics, but I just always wanted to be introduced to somebody who had. So let me start. Why? Most of you, I'm suffering a little bit because, of course, I'm used to speaking to people where I can look them in the eye and see their quizzical looks. But most of you have probably either been to or seen advertised a personal estate planning seminar, or or a dinner, or some kind of a presentation, in which invariably, after you're done with your rubber chicken, you are invited to have an estate plan done more or less there on the spot, or to make the arrangements. And I don't want to categorically condemn anybody who does that, but I want you to close your eyes with me for a minute and imagine that this was in fact a dental hygiene seminar that you signed up for, and that I got in front of you and I said, you know, you may not realize it or not, but each and every one of you out there needs a root canal. I know, it seems strange, but I can tell that each one of you needs a root canal. And as it happens, I have a dentist outside in the lobby. Normally a root canal is $3,200. Tonight, $1,600 only. And go ahead and take a number for better service. You wouldn't stay around to have me finish that sentence because, of course, it's absurd. It's absurd because nobody could possibly know whether you need a root canal or not. Well, I'd like to say similarly that even though I'm talking about 4 tickets to a lawyer-free retirement, which is something we all should aspire to, one size does not fit all. And so to suggest that you need a living trust, that you need an annuity, that you need an investment vehicle or something like that without knowing anything about you or your family or your preferences or your situation is frankly malpractice. So I'm not going to do that. I'm not going to say everybody needs to do it this way. What I am going to say is that there are things that you can do now that will pay you considerable dividends in the future, because you are unique. Your family is unique. Your needs and wants and desires are unique. And having an estate plan that answers all of those needs is what you really want to do. Having said that, I'm going to talk about that's a lawyer looking for that last dollar. I'm going to go through 4 tickets to a lawyer-free retirement. Some of you may remember the Mr. Dirt commercial, pay me now or pay me later. I do probate litigation. I don't particularly like to do that because usually it means that families are fractured, they're at war with each other, and the result sometimes tragically can be that families are forever separated over will contests and so forth. And I view it as my mission this afternoon, insofar as I'm able, to prevent that from happening to you. Okay, so what is the first thing to do? Make a will and keep it up to date. Now, you may say to yourself, well, I don't really have much of an estate. Why do I need to have a will? Well, let's talk about why you need to have a will. First of all, it makes sure that you transfer property to the people that you want to transfer it to. Without a will, the state law is going to decide where your property is going to go. And that may not be where you actually want it to go. It can go, for example, it can go to your ex that you don't intend it to go to siblings that you don't want to have as part of your estate. So it gets the property to the right people and not the wrong people. So let's digress. Who are the wrong people? Do I have any suggestions from anybody? Right. We're on Zoom. Let's see.
Government.
Okay. I'm going to start with this. These are the wrong people. This was the last local bar meeting here in Colorado Springs. The first one is the tax collector. Now, having put that number one, believe it or not, under the present law in Colorado, and I understand that there are some people that are listening in from out of state. So bear in mind that Colorado, that every state has its own probate system. And so what's good advice in one state may not be applicable in another. But until about the year 2000, the federal estate tax, which always kicks in at roughly the highest personal income tax rate, which right now would be 40%, and quickly goes up to 50%. If you had $1 million estate, you were going to be paying federal estate tax. Today, because of various changes in the law, most recently the Tax Reform Act of 2019, so-called Trump tax, unless you and your spouse or partner have $23 million, you don't have to worry about tax in your estate. So many of the tricks that we used to have as a estate planning lawyer that would try to maximize the amount of your estate that would get to your actual heirs and beneficiaries, you don't have to do that so much now, because I have exactly no clients with $23 million in assets. That is what's called the federal estate tax. The federal estate tax has what it's called an applicable exclusion amount. And that amount is what you might call as your deductible, the amount of money in your estate before you actually have to start paying. Now, many states have their own transfer or inheritance tax. Until recently, Colorado had one too. It was called a parasite tax. And basically, it just tacked on. It said, whatever the tax is that you are sending to the federal government, send us 7%, which was the maximum tax credit. So mail that to us. So if you had a $100,000 tax credit, you would mail $93,000 to the IRS, and you would mail $7,000 to Colorado. That tax credit, state tax credit, has also gone away. And therefore, Colorado has no inheritance tax either. So it is no longer necessary to try to do your estate planning in such a way as to avoid taxes. Okay, I'm going to bet that nearly all of you also, unless you have the misfortune of having a child or somebody who's a lawyer, in which case I can offer intervention. But I'm going to assume that most of you don't want your estate to go to lawyers. And why do lawyers get a portion of it? Well, in some states, lawyers will charge a percentage of the probate estate. In Colorado, that is, although it's strictly speaking allowed, it's just not done. For the most part, probate in Colorado Springs, for example, may be something where you pay a $2,000 retainer and you may probably end up getting money back. The way lawyers will be taking your estate is if there is an ambiguity in your will, if there is no will at all, and you have people fighting over who is entitled to the estate. Litigation in an estate is what can eat up more money than almost everything else put together. So you want to have a will that is clear, that will avoid litigation. And then I just refer to assorted crumb bums who are not on your Christmas card list. And who is that? Well, that might be an ex, that might be a brother-in-law, That might be somebody who anymore is estranged and alienated from the family, and you don't want to take, unless you have that in your will, they may take automatically as a matter of law. Here's another reason to have a will. Some people have the idea that when you have a will, you have to say, okay, I will my car to somebody, and I will my art collection to somebody else, and my coin collection over there, and my favorite antique bed. No, for the most part, a will is going to say, for those who are married, everything to my spouse, if she survives me, and if not, then to my children in equal shares. That's kind of a typical distribution. But many of us have certain specific items that may not be worth a lot of money, but can't be divided evenly among the children, for example. And I actually have a visual aid here. This is an A26. It's a hand-carved wooden model made in Korea. It's absolutely beautiful in its precision and its craftsmanship. It's what my dad flew in Korea, and he won the Silver Star flying it. That would not look good sawed into 3 different pieces for the 3 of us. So what Colorado allows you to do is to put into your will, I'm going to have a personal property memorandum, and I'm going to list things that will go to different beneficiaries without having to change my will every time. And simply by having that paragraph in your will, you can prevent fights over things like this. Because often you may have only boys in your family, and you have some jewelry that's come down through your side of the family that you want to go to a niece or somebody like that. This gives you an opportunity to put down that list. I have to tell a story. Had a client, and unfortunately she was suffering from dementia. And so we were trying to get her affairs in order. And she had a lot of very, very nice things. She had been a world traveler. And so she had 5 children, and they came to the house one day, and everybody got a different colored yellow or sticky. They got pink sticky, a blue, this one was blue, you're yellow, you're green, and so forth. And the object was they would go through the house and they would put a sticky on a piece of furniture or some artwork or a picture or a knickknack or something like that that they wanted. And therefore, we could just put it into the personal property memorandum. So that happened. And there were a lot of stickies because she had nice things. The next day, she got up having no memory of what happened and said, "What the hell are all these stickies doing around here?" And she tore them all off. And there they were on the floor the next day. So this is a chance for you to be very particular and to have the kids or whoever your heirs or beneficiaries are come over and say, is there anything that mom or dad have that you'd like? You'd be surprised. You say, oh, they don't want anything, but sometimes a blanket that somebody had as childhood can be very, very special. And this is your opportunity to allow them to do that, and then to put a personal property memorandum together, and then to allow your personal representative to distribute those and not fight over them. And have there been fights? I had a family where he had done quite well investment wise, and they had about $3 million, and they had 3 children. And they had a will that said everything to my children in equal shares. Well, it's easy to divide 3 million into 3 children into 3 million. But that wasn't good enough because there was no personal property memorandum, and a lot of kind of simmering hostility and resentments and so forth just erupted. And they ended up probably spending around $30,000 in attorney's fees fighting over knickknacks for the most part. I had a pair of brothers that spent about $15,000 fighting over Mattel Hot Wheels. So Colorado is really user-friendly in allowing you to do a personal property memorandum and head off family fights over little things, because kids will fight over the darndest things. And it's also important, most of us families have each other, our spouse, as our primary personal representative. And then upon the death of the surviving spouse, one or the other of the adult children becomes the personal representative. And that's personal representative is the term that we use for executor. You don't want to put a child in the position of wanting this A26 when somebody else wants the A26, and then they have to make a judgment as to where it's going to go. And so one of two things happen. Either they give it to the other one that wants it and then they resent the other one, or vice versa. Either way, things like that can be headed off and can really just save a lot of trouble in the way. And it's also a way to keep heirlooms in the family. Again, some people have heirlooms, pieces of jewelry, or World War I Luger, that sort of thing that want to be passed down to the children, to the grandchildren, sometimes the great-grandchildren. This is an easy way to do that. Okay. This is, if you listen to nothing else here, this is probably the most important aspect about a will. A will does not pass everything in your estate. Say again, a will, generally speaking, will not pass everything in your estate. It will pass what's called your probate assets, which is something that you owned in your own name in some fashion. It's your tangible personal property. It's things that you own as tenancy in common. What it is not is a joint tenancy. So you and your spouse, most of us, have a joint checking account, maybe a joint investment or brokerage account with our spouse. And that's a smart thing to do, because at the passing of the first to die of the partnership, everything passes automatically, without probate, without a will, to the other joint tenant. So it makes perfect sense to do it between, as I said, between husband and wife. It does not make sense to do it, usually speaking, with a child. And I've seen that before. Let's assume that you have 5 children. I have 5 children. Let's assume you have 5 children, and it's everything to my wife if she survives me, and if not, then to the children in equal shares. But I say, well, you know what? I don't want to have things tied up in probate, so I'm going to put our checking and savings account in joint tenancy with my oldest son. That would mean, at the passing of the survivor of the 2 of us, my oldest son would take everything in that joint account, and it would not count against his share. Repeat, it would not count against his share. So without meaning to, people can actually create a tremendous inequity among the children, simply trying to maybe save time or probate or money, and it does none of those things. Likewise, more and more of us have IRAs, 401ks, and so forth. IRAs and 401ks pass by beneficiary designation, not by will. So when you fill out the paperwork for your IRA, you may, as most of us do, if you have a spouse, put the spouse as the primary, and then have the children as secondaries in equal shares. And that works just great because it's consistent with your will, but it does not pass by your will. If you pour an IRA or a 401k into your estate by making the estate as a beneficiary, the IRS takes the position that it's as though you withdrew the whole thing all at once, and there will be an income tax consequence to doing that. Now, most of you know who have IRAs and so forth that the rules on that have changed recently, and they have to be paid out over a certain amount of time and years. And then you have something called RMDs, required minimum distributions, which goes beyond the scope. But the point I need to make here is that if you do have these things, make sure that the beneficiaries harmonize with your beneficiaries in your will. There's also another trick that Colorado has that not all states have, and that's called a beneficiary deed. A beneficiary deed allows you to deed your house over to somebody if you want to do that, and you still have it for the rest of your life. You can buy it, I mean, you can sell it, you can rent it, you can mortgage it or anything else, and the beneficiary deed only comes into play at your passing. And that's if you still own it. And then it goes automatically to whoever you designated as beneficiary. This sounds like a really easy way to avoid probate, but it really in practice only works effectively if there is a single child. For one child, where that child's going to be getting the property anyway, frequently the marital home, beneficiary deed makes a whole lot of sense. If there's more than one, you don't want to have a bunch of children as tenants in common, because they all have to agree to sell it or not to sell it, and we're back into litigation. Transfer and payable on death accounts. I want the end people here to plug their ears, but there has been certain financial institutions, of course not End, where somebody says, you know, you can open up this checking account or the savings account. Why don't you make it transfer or payable on death to one or the other of your children, and that way you'll avoid probate. The same thing happens with POD and TOD accounts. They go outside the will, and they will invariably, unfairly benefit one or the other of the children that you have as TOD, POD. If you have a will, there is absolutely no reason to do transfer or payable on death. It doesn't save taxes. It doesn't save time. It doesn't save litigation. What it does do sometimes is create a real inequality. Had a situation where a woman had basically everything that she had was in an IRA, and it was worth around $30,000. She had 3 children. One was an adult son, and then she had 2 minor children who were still in school. She died, unfortunately, relatively young, and she had that $30,000 account payable on death to her son, and with the expectation that he would use what little there was there to take care of his sisters. Well, he didn't. He bought himself a truck and disappeared. And legally, he could do that. There was nothing wrong legally with what he did. Morally, that's another question. So that's always important. So when people come to me for estate planning, one of the first things I ask is not only what are your assets, generally speaking, but how are they owned? Because POD and TODs and beneficiary designations and so forth all need to be fitted together so that in the end, people get what you want them to get. Okay, and I just talked about the estate tax. So as you can see, $11,580,000 per person and 40% tax rate. I doubt that there's anybody listening to this that applies to. So here is something which I think is important, and that's to make your estate planning an instrument of reconciliation and not retribution. And I will confess that the advice I'm giving now is maybe not so much legal as it is kind of practical. And that is this. I have seen the other side of will contests. I have been involved in will contests, and they are always very, very discouraging things to do, because you see people who are brother and sister, grew up together and so forth, and suddenly for whatever reason, they're at odds. There are families where there's a black sheep. There's somebody who has been alienated maybe from the other family, somebody who may have been, on America's Most Wanted 2 or 3 times. And I see parents who come to me who say, I am going to make sure that crumb bum doesn't get a nickel from us. I want to cut him out of the will. And that sounds like, well, gosh, that's only simple justice, isn't it? Because some of the hurt that children can visit upon their parents and grandparents is almost unfathomable. But when somebody says that, I always say, can we sleep on this? And the reason is this: what you are doing when you decide to punish somebody with your will is that you're not there inflicting the pain. Effectively, you have enlisted your other children to do that for you. And so that black sheep who already maybe has anger management problems takes it out on the people that he thinks were beneficiaries of his parents' decision-making. And the one thing I can guarantee when that happens, I can't guarantee a will contest, although it's likely, but I can guarantee that whatever happens, any hope or chance for reconciliation with that one child is over. There won't be any 4th of July picnics. There won't be any Thanksgiving dinners. There won't be anything like that. They will talk to each other the rest of their lives, if at all, through lawyers. And that's the sign, I think, of a failed estate plan, because the one thing we can all agree on is we want our families to come together and not to blows at our passing. This is also important. You can now do organ donations in your will. You can specify that. It's enforceable, as are funeral and burial arrangements. It may sound kind of strange, but again, if you want peace and harmony with your children, the more specific that you can be about things like this, the better. And I will take a very personal anecdote. My mom and dad died just 16 days apart. I mean, he knelt at her casket and said, "Take me with you." And 2 weeks later, he was gone. But as a result, my mom passed first. That wasn't supposed to happen. That wasn't the plan, but that's what happened. Dad was not able to do the planning and the arrangements, so it was left to me to do that. And Mom was a Catholic, and so she did have a viewing and so forth. So Dad said, "Go pick out a dress for your mom." So I did. And the last thing you want to hear when you're grieving is, what were you thinking when you put Mom in that dress? She hated that dress. Well, what was it doing in her closet if she hated it? But it's a sounds trivial, but you can't imagine how that kind of thing can really hurt. You don't want your family to, once again, be uncertain about what you want, whether it's funeral arrangements, whether you want a service or not a service, what hymns you want if you're going to have a service. The more that you can specify that to your family, the better it is. Because then they can all be confident, this is what Mom wanted. And she would not have wanted that blue dress. I also occasionally see something like this. Sometimes families may have some property, out by Woodland Park or in Breckenridge and Summit County and so forth. And they have this property and they want to make it available to their family, but they don't want to just deed it outright to the family. And in this case, you can create what's called a recreational property trust, where you basically put that property in trust and you allow family members to use it. And it can go on beyond just, your lifespan or that of your children or even your grandchildren. So that's another thing that you can do with a will. Also important, special needs trust. Some of us may have children who have special needs, and they may be receiving public assistance. They may be receiving disability. They may be receiving SSI, which is supplemental security income. But for children with profound disabilities who have had that from birth, they're going to be receiving Medicaid assistance, even of course as adults. And so if they suddenly receive a lot of money, the state is apt to take it right back, depending upon what they have received in the past. But you can avoid that with what's called a special needs trust that you incorporate into your will, and makes it possible for them to enjoy at least some benefits from your estate without disqualifying them for public assistance. And this one is probably as important as anything, which is handling blended families fairly. I spent 30 years in the military, and I started off as an intelligence officer in Vietnam, and believe it or not, they needed more lawyers than they needed fighter pilots at the end of Vietnam. So they sent me to law school. And so we would do legal assistance for people. And blended families became more and more the norm. And the simple everything to my spouse, if she survives me, and if not to my children in equal shares, doesn't work if we're talking about, previous relationships and previous children. So there's a very easy way to make sure that the children of the first to die don't lose out. But again, it takes a will that takes that into consideration. So no will means state law decides who gets your estate. The legal presumption is that the spouse will be a principal, but not necessarily the exclusive heir. You can disinherit anybody that you want. No child or niece or nephew or brother or sister or parent or anything has a right to make a claim against your estate, except a spouse. You cannot disinherit a spouse, at least entirely. You can limit it. And there are, sometimes people try to do that, and when they do, it's going to be really kind of a slugfest, a feeding frenzy, because the surviving spouse has the right to what's called an elective share, to family allowance and to exempt property allowance. And those two allowances alone come to $70,000. Children under the state laws of intestacy, including those from a previous marriage, will take equally if you don't have a will. And you can sometimes find a situation where if your spouse dies, that your stepchildren now become your co-tenants and the co-owners of your house. And that sounds bizarre, and it is, but I've seen it happen. And of course, that personal property memorandum is not enforceable. For those of us with minor children, the state decides who gets your children, unless you specify in a will. And remember, as I told you earlier, non-probate beneficiary designations will always trump the will. So joint accounts, transfer on death, payable on death, and beneficiary designations will go to those people that you have designated, irrespective of what the will says. And then a personal representative is not designated if you don't have a will. And so sometimes there are children that will fight over who gets to be the executor. Anytime you can avoid a fight, it's good work. And almost without exception, without a will, probate and administration will be more, not less expensive. Because a will eliminates the ambiguities and makes clear what your intentions are, a probate administration is really, really easy with a will. I want to go back here for just a minute here. There's, when some of these people at the seminars try to sell you a living trust, invariably what it says is you can avoid probate. And then they charge you more for that trust than probate cost. I'm going to make a sweeping statement here, but I can back it up. Colorado has the fastest, easiest, most user-friendly, and least expensive probate system in the country. Done the way I do a will, and most of us do a will. Probate involves lodging the original will at your local county probate registrar. In my case, I would then file about 4, sometimes 5 documents, and that I can file right here at my computer, press a button, they're filed within a week to 10 days in El Paso County. Your estate is probated. It's that easy. Don't have to go into court, don't have to testify in front of a judge. It is very, very straightforward. I tell people often it's not. When you have a beneficiary designation or a joint account, those require a death certificate in order to be transferred. And I can usually probate a will before most people can get a death certificate. That's how easy Colorado is. So if you're being told, well, you can avoid probate, probate is not something that necessarily needs to be avoided. I would argue that you want probate because one of the neat things about probating a will is that it starts a 120-day clock running on creditors. And if the creditors don't get their claims in, and that includes Capital One and credit card companies, they're out of luck. Okay, ticket number 2 is the general durable springing power of attorney. That's a mouthful, but let me unpack that a little bit. What does it mean? A power of attorney is where you designate somebody who can act for you when you can't act. But let's talk about springing and durable. At common law, which is where we get all these ideas, an agent would have no more ability and capacity than the principal. So if the principal is suffering, maybe has a stroke or suffering from dementia or something like that, and can't make decisions, at common law, the power of attorney couldn't do that either. So when you needed a power of attorney the most, it wasn't available. Well, every state in the union has now created what's called a durable power of attorney. And durable power of attorney means that it survives your incapacity. So if you do suffer from a temporary disability of some kind, the person you've designated as the power of attorney has the authority to step up and do things for you. What does the springing mean? The springing means that it comes into effect only if you are incapacitated. Before you went over to Vietnam, you always had to go through this processing line, and they would give you a general power of attorney, and most people would designate their spouse to be their power of attorney, and they would come back to find that they've been divorced in absentia and were paying superable alimony and child support, and all done with a power of attorney. So this need created something called the springing power of attorney, which says this thing is effective only if you are incapacitated. So most general powers of attorney, and general power of attorney, think of that as the financial power of attorney. Most of those are durable and springing. So they are effective in the event of your incapacity, and they only come into existence, or they're only effective in the event of your incapacity when you need them. Why are they important? Unfortunately, I do in protective proceedings. Protective proceedings are guardianships and conservatorships, where somebody may be suffering from Alzheimer's or maybe a stroke or something where they're temporarily or maybe even permanently incapacitated. If you don't have a durable springing power of attorney in effect at that time, the only way somebody can take care of the bills, make sure the mortgage gets paid, make sure the water heater gets replaced when it blows up, is if you actually go to court and get a conservatorship. Now that is expensive. That can be thousands of dollars, where in essence a court is going to appoint somebody to look after your financial affairs. The fact that you are married and that you have a spouse does not give them the authority to speak for you. Without a power of attorney, even though you're married, they do not have the legal authority to sign your name, cash your checks, or anything like that. So having a power of attorney is very, very important, because you have essentially said, in the event that I'm incapacitated, here's who I want to have the authority, and it's signed and it's witnessed and it's notarized, and that can save a conservatorship. It is a very good idea for long-term care planning. Sometimes I have couples who are clients where one or the other of them is in the early stages of dementia, still has capacity, but understands that sooner or later, and sometimes it's sooner, they're going to be at a point when they're not going to be able to look after themselves. And getting a power of attorney is a good way to make sure that we don't suddenly find ourselves in court. A power of attorney also has the ability of saying, I don't want a guardianship or a conservatorship, but in the event that one comes to pass, here's who I want to designate to be my guardian or conservator. So a power of attorney, a financial power of attorney, is very important for disability planning. As we get on in years, more and more of us want to say, what if something happens to one of us? How are we going to be able to handle that without having to go to court? And one of those is, since both husband and wife have usually own their house as joint tenants with right of survivorship, you want to have a situation where if one of them is incapacitated, you can still sell that house. You want to have it so that somebody can sign state and federal taxes for you if you're not able to take care of those yourself. And then in some cases where you may have a very modest estate, and we are looking at some long-term care planning for one or the other of the spouses, you can build into your power of attorney something called a Miller Income Trust, and provide for the purchase of community spouse annuities. And again, this is all kind of gobbledygook, but it is a way to make sure that a spouse is not disqualified for Medicaid assistance, which can be done. And you can contract for long-term care for a spouse. And if it comes time to downsize, once again, if you want to sell the family home and you hold it in joint tenancy, you may very well want to have a power of attorney where each of them says, even though I own the house with my spouse in joint tenancy, they have the authority to sign for me to sell it. And it's good for gifting to the family. That's not so much a thing anymore, because once again, primarily, annual gifts to the family used to be a way of reducing the size of your taxable estate. Again, unless you are uber rich, that's not an issue anymore.
Hey, Skip, before we move forward on the next slide, just because we're getting through some time here, we have several questions in the chat. Do you mind maybe taking a look at the chat to see, because some of it relates to what you've already talked about? And maybe
sure,
do you
tell
mind
me how to do that. Let me see.
So
Oh, here it is. Okay, I've got it.
perfect. Thank you. Maybe
You
if we
want to
just
go
want to
back
address,
to the beginning? You want to go back to the very beginning?
I think if he just
I'm-
looks through them, Pamela, and maybe answer some of the questions that he's already
Okay.
addressed, and then maybe
Yeah.
save some of them for the end, if that's okay.
Okay, I've got, probably this is from last to first. Oh, no, here we go. How is a safe harbor trust used? You know what? I'm not even sure what a safe harbor trust is at this stage. What's the difference between an estate and a will? A will is what passes your probate estate. That's the one that says everything to my family in equal shares. The estate is what's in the will. Now, you got two kinds of estates. You've got probate estate, which is the things that are in your own name. And then you have your non-probate estate, and those are IRAs and joint tenancies and so forth. Let me see. How is an irrevocable Medicaid trust used, and when should somebody establish it? I'm glad that question. You see the slide that you're looking at right now? I'm going to talk about an irrevocable Medicaid trust. I will make it very plain. I'll give you a sneak preview. They are a very bad idea. When should you use a trust as opposed to a will? I kind of talked about that. In Colorado, in my judgment, there are two reasons to use a living trust and not a will. One is if one or the other of the partnership, the spouses, is suffering from dementia, which is in rapid decline, but may otherwise be in very good health. And you don't want to have a situation where somebody with dementia or who is no longer capable of really managing financial resources suddenly comes into the entire estate for both husband and wife. The reality is that one or the other of the spouses is usually carrying the other one, is making sure that the bills are paid, is making sure that meals are prepared, is making sure that medical appointments are being made. But if that person passes, suddenly you have potentially a really disastrous situation. And I mean, a real life experience not too long ago where wife had dementia, fairly severe. And children were scattered to the four corners of the globe and did not know how far mom had regressed. And she was able to put on a good front and say hi, and happy Thanksgiving and that sort of thing. Where if you were actually spending some time with her, you would realize soon on that she was really suffering. In that situation, I would suggest a living trust, because essentially the able spouse can set up something that at his or her passing will make sure that one or the other of the children or responsible adult will be there to make sure that the disabled spouse is not exploited, because that can happen. So that's one good reason to have a trust. The second one is if you have real estate in other states, because states are very jealous about dirt that they find inside their borders. And even though your will says everything goes to my brother, the other states are going to make you go through probate in those states. If, on the other hand, you have that real estate owned by a trust, then you can avoid probate in those other states, which almost invariably is not going to be as easy or as inexpensive as Colorado. Okay, and then we got, what's a good way to protect your pet from not ending up in the Humane Society? Believe it or not, there are pet trusts. There is such a thing as a pet trust, which you can put into place in your will and say at my passing, then there's going to be a certain amount of money that's going to be set aside for my pet, and I want to make sure that it is not put up for adoption. But yeah, I do those. Does a personal property memorandum need to be notarized? No. As a matter of fact, as long as you have that magic paragraph in your will, you can write it in Crayola on a Big Chief yellow tablet, and it's enforceable as long as it's clear as it's something that you did. Can my personal property memo can be edited without another notary? Yeah, I mean, there's somebody, if you just put something down in a Word document, on your computer, well, then anybody can mess with that if they want to. So it's always a good idea to sign it yourself. And if you change it, just create a new one and sign it and attach it to your will. In order to get a will, do you have to be a certain age? You have to be 21.
How long is this going to go?
If I have a will from another state, how do we update it from Colorado? You may not need to, believe it or not. You may not need to update your will from another state because full faith and credit clause of the Constitution says that Colorado will honor that will unless it's against public policy. And that's rare anymore. On the other hand, powers of attorney are things which tend to be very specific to the estate, to the state where they're done. And I always recommend that you get powers of attorney that are applicable for the state that you're living in. What is a trustee role as opposed to a personal rep? The trustee is just that. He is the trustee of a trust. The personal representative is the executor of your estate. Those are two different legal entities. So the job of a personal representative is to, upon the passing of the testator, to gather the estate, the probate estate, inventory it, pay off the creditors, distribute it to the beneficiaries, and they're done. A trustee's role may go on well beyond that because it is to administer all the assets in the trust in accordance with what the trust says. What's a good strategy for a single person? I guess it depends on what your objective is. A single person, the laws of intestacy are it's kind of reminding you how you cross yourself, is that your children take everything, and if there's no children, then your parents, and then if your parents don't, then laterally to your siblings. That's essentially what, but a single person needs a powers of attorney just as much as anybody as a married couple. Because if something happens to you, you want to know that there is somebody who can go to, who can speak for you at a hospital. We haven't even gotten to medical power of attorney yet, but that's important. What happens if one spouse is on the mortgage, but the other spouse is not? Does the house automatically go to the spouse that is not on the mortgage? No. The mortgage and the deed are two entirely different things. So the house is going to go to whoever the deed says it's on. The mortgage is going to belong, and it potentially can be a liability of the estate if the spouse that's on the mortgage passes away first. Can PODs be broken into percentages? Absolutely. There's a will when you're dead, but a living will can be used when you are still alive. Actually, a living will is a different thing, and that's the last document I'm going to be talking about. A living will is basically an advanced medical declaration about what you want your doctors to do and what you don't want them to do in the event that you are terminal. It is not the same as a living trust. Average price for probate if you have a will. I usually will take a retainer of $2,000 and I will simply earn it at my hourly rate, and often as not, I end up giving money back. So probate in Colorado is, as I said, very inexpensive. Okay, we got a little bit behind here, but let's catch up. VA aid attendance. Some of us may be bringing elderly parents or grandparents or people into a nursing home, and you have somebody there who is going to sell you an irrevocable Medicaid trust. What is that about? For VA aid and attendance. VA aid and attendance is a benefit that you have from the VA that is resource-based. And that means that you can only have a certain amount of money. Medicaid is the same way. You can have virtually no money to qualify for Medicaid. Your estate has to be worth $2,000 or less of countable assets. So you're sold this irrevocable trust to qualify for VA aid and attendance. And the way that works is basically you give away everything that you've got and you put it into a trust. And then you start to collect VA aid and attendance. What they don't tell you is the moment that it goes into this trust that is drafted usually by an out-of-state attorney, they will immediately liquidate everything that's in your estate and they will buy high front-end load annuities where they will make tens of thousands of dollars paying themselves to purchase annuities in the trust because it's irrevocable, no longer have any say over it. And that they also will not tell you is that to keep Medicaid, you cannot have made any gratuitous transfers within 5 years of being eligible for Medicaid. And an irrevocable trust is a gratuitous transfer. So what they don't tell you is you have probably disqualified yourself for Medicaid for at least 5 years, if not longer. And they'll also tell you that it shelters assets from creditors in the estate, but you don't want to have those assets sheltered from creditors in the estate because the people that sold you that irrevocable trust will take all the assets anyway. So if you are in that situation or your folks are or something like that, and you get offered this VA aid and attendance irrevocable trust, do yourself and your parents a really big favor and see a lawyer who knows about this sort of thing before you sign on the dotted line. Okay, medical durable power of attorney, want to kind of step on it a little bit, but as important, if not more so, from the general durable power of attorney or the financial power is the medical durable power of attorney. Once again, even if you're married and you've been married for 50 years and your wife is face down because she's had an accident at Penrose, Maine, they will not even tell you that she is there at Penrose, Maine, unless you have a power of attorney. Never mind that you're married. So it's vitally important that you have a power of attorney so that in the event you're not able to speak for yourself, you have somebody who can go into the hospital and advocate for your interest. Very important. Had a situation where a woman was suffering from dementia and she was tended to do as some people like that do. They tend to elope. They just wander off. And one night she wandered off and just disappeared in the middle of the night. And her husband awakens and he's frantic and he starts calling everywhere to hospitals, to anybody to see if they found her. And once again, they won't speak to him. Worse, when she was finally picked up by a local medical facility and taken in, she denied that she was married, even though she had been married for 40 or 50 years, because she didn't remember her husband. I mean, so having a power of attorney, having that with your medical provider and so forth can save valuable time in making sure that when you are in an extreme situation, somebody is there who has the legal authority to step up and help you. Okay. And once again, in the same sense that the financial power of attorney avoids a court-ordered guardianship or conservatorship, this avoids the guardianship because in the situation that I started to talk about before, where husband was covering for the wife, and she had pretty severe Alzheimer's, and nobody knew it. He had a stroke. He's taken away by the EMT people. They find her 3 days later, face down on the living room rug. She hadn't eaten. She didn't have water. They were able to save her, but because there was no power of attorney, they had to take her in for a guardianship, and that's going to court. And somebody then had to be appointed by the judge to look after her. Powers of attorney, you avoid that. That says that you're the boss of you until you're not. Very important. A power of attorney is, on its own terms, a springing power of attorney. That means you don't have to worry about, well, my children are going to, put me in a nursing home because I give them a power of attorney. No, as long as you have capacity, you are the boss of you, no matter what that power of attorney says. And that brings us to the living will. Living will is, it's an advanced healthcare directive. And it is an order to your healthcare providers that tells them what you want to do and what you don't want to do under certain circumstances. It's increasingly important these days because you want to be able to have control, even maybe in your closing days or months or so forth of life. The way I do one, and I will use that as an example because it corresponds with Colorado law, but also I want it tailored to the value system of my client, is that 4 criteria need to be met. 1, I'm unconscious, in a coma, or otherwise unable to make or communicate my decisions. 2, I suffer from a terminal disease or condition from which there is no reasonable expectation of my recovery. 3, my physician and 1 other physician certify the first 2 in writing. And 4, and this is critical, that I have been in this condition for 7 days or more. I want a living will to speak to your values and speak to what you want to have. But by the same token, I do not want doctors who don't know you, who don't understand your beliefs, your values, and who have kind of a built-in conflict of interest. And I don't mean to slam doctors, but the fact of the matter is, if you're using valuable machinery and healthcare things like a ventilator, that it's too easy, I think, maybe to give up. I had a case recently which I think is important to understand. I had living will along the lines of what I just mentioned to you. And a woman had a massive stroke, and she had her estate planning done with me. She had just 1 child, a daughter, an adult daughter. And she was unconscious. She was in a coma. And every day and every night, daughter would come to her hospital bedside and just talk to mom. And she would hold her hand and she would stroke her and she would talk to her, and mom was non-responsive. Well, 7 days came and went. And the doctors approached the daughter and said, your mom's living will speaks to this very situation. It's been 7 days and maybe you should think about letting her go. And what she said was, last night I was talking with mom, as I've done every night, and I was holding her hand and she squeezed it. She squeezed my hand back. She did it more than once too. I think mom might come out of this. So let's wait. So they did wait. And happily, mom made a full recovery. And I'm not talking about a twilight existence or anything like that. She lived for another 1.5 years after that time when, otherwise they might have given up on her. So this is a great way to integrate your medical power of attorney with your living will, because in the end, I think most of us want to have our loved ones making that decision, as painful as it might be, rather than somebody who doesn't know us. A living will is not a do not resuscitate order. That is something entirely different. But it does speak to things like feeding and hydration. The truth of the matter is that living will really is kind of looking at the long-term debilitating diseases like cancer, where when the 7 days is up and they withdraw feeding and hydration, nourishment and hydration, that's what you're probably going to die of, because you don't last very long without any water. There are many people, because of their faith, who will not allow the withdrawal of nourishment and hydration. And that's something, again, that you want to tailor that living will. But it does deal maybe with dialysis, and it does deal with ventilators and heart-lung machines. Physician-assisted suicide is now legal in Colorado. Theoretically, it is something which somebody has to be competent to make, but in terms of what I have seen in other places in other states that have this, there will come a time when somebody is going to come to court and say that, I think Grandpa probably would have wanted to be put to death in this situation and would want medical assistance in dying made. And to not allow him to do that is kind of a violation of equal protection, which is all a long way of saying, if you feel very strongly about that, your living will needs to speak to that very specifically. The living will complements, it doesn't duplicate your power, your medical power of attorney. Your medical power of attorney appoints somebody to do something whenever you can't, even though you may be perfectly healthy. You may have a situation from an automobile accident where somebody needs to be making arrangements for your care and for rehabilitation and so forth, and that's what they're there to do. The living will deals only with end-of-life situation, but I always knit the two together so that ultimately the person having your medical power of attorney will be the one who will make that final decision once the doctors say that the criteria have been met. Colorado also has something which is the medical order for scope of treatment. It's a most form. Some of you may be familiar with it. It's a green form. That is or can be a do not resuscitate order and other things where you say what you want, what extraordinary means you want the doctors to use. So they overlap to a degree, but a medical order for scope of treatment is different from a living will. Oops, I wasn't responding. Okay, talk a little bit about appointing fiduciaries. What is fiduciary? Well, in the context that we have been talking about it, your personal representative is a fiduciary. The person you appoint as your medical power of attorney is a fiduciary. As your financial power of attorney is a fiduciary. Your trustee is a fiduciary. The lawyer that you hire to do probate is a fiduciary. These are people that owe a loyalty to you or to your estate that is to transcend their own selfish interest. So people often will ask me, who do I appoint? So we just talked to some of the people. The fiduciary has got a great deal of discretion and a lot of latitude. Done the way probate is done in Colorado, it's unsupervised. It's an administrative process. There's no court involvement looking over the shoulder of your personal representative, which means that you really do need to trust your personal representative. Trustees, the same way. They administer trust, they invest, they distribute the income and appropriate. They file necessary legal and tax documents, but they are a fiduciary to the trust. Guardians and conservators and people you appoint in your powers of attorney are also your fiduciary. So that's a pretty extensive list. When you come to do estate planning, you need to have in mind who your fiduciaries ought to be. I'm often asked the question, well, in my case, you have 5 kids, which which one do you think I ought to make the personal representative? And do you think I ought to make them the power of attorney and then just list them 1, 2, 3, 4, 5, because I can't afford to hurt any of their feelings about it. And I say only half jokingly, pick the one you hate, because being a personal representative is no fun when you have siblings who are some of whom who want money, when they want it distributed right away, who don't understand things. It can be a very, very difficult thing to do. It's not an honor. And I tell them when they make their selection, tell them it's not because I love you more or love you less, or I trust you more or trust you less. The lawyer said I could only do one. And my real advice, when you're picking, typically, again, among your children for your alternate power of attorney and for your alternate personal representative, is pick the one that gets along best with his or her siblings. That is the ticket. Doesn't have to be the lawyer, doesn't have to be the accountant, because all of these tasks are made relatively easy, and lawyers like me kind of act as coaches for them. But the one that has the best relationship with the siblings is always the right choice, always the right choice. And the same thing, I think, for trustees or anything else. So, and you don't have to go 4 and 5 deep, not to hurt anybody's feelings. It just doesn't make sense. And you never, I say never, I can think of almost no reason to have co-fiduciaries. Some people say, well, I got 2 children and I don't want to choose one or the other, so I'm going to make them both personal representatives. That's a prescription for more expense and more headaches, because there are some banks, investment firms, and so forth who insist if there are co-fiduciaries, they want to have their gold medallion signatures on every single document. And so what's normally a relatively clean and straightforward purpose can get very, very complicated in a real hurry. So there's really no good reason to have co's. Have one, then the other, but not co-fiduciaries. Okay. What I call ticket 4.5, which is the SMART book. All of us have heard of the philosophical question, what happens if a tree falls in the woods and there's nobody here there to hear it, doesn't make any noise? And what if you have this marvelous estate plan, but nobody knows where it is? You might as well not have it. If the original will cannot be found, that really simple, and you can only find a copy, that really simple probate that I talked about, now you are going to be in court, you are going to be in front of a judge. Because Colorado takes the position that if the original will can't be found, it's because the testator meant to destroy it. You can prove to the contrary, but you're going to have to go to court to do that. So you want to put the will in a place where it's safe. We have learned recently in Colorado Springs area that fireproof safes aren't. But it needs to be in a place not only where it's safe, but you also want it in a place where your alternate personal representative knows where it is and has access to it. And you do that with, I provide kind of a notebook with all these kinds of things that says, here's where these things are. If you put it in a safety deposit box, as some people do, you want to make sure that your alternate personal representative knows it's in that box, that your bank or credit union knows that those things are in the box, and that person has access to that box in the event of your passing or incapacity. So that's really important to make sure that that will is safe and that the right people know where it is. If God forbid that some of you have or may have a disabled spouse where Alzheimer's is starting to run its terrible course. Make sure the family knows about it. Please don't hide that. Because if they are ultimately totally reliant upon you and something happens to you, they are adrift and they are really, really in harm's way. So make sure that the family knows, make sure that there are regular checkups to make sure that mom or dad is safe. Bank accounts, investment accounts, CDs, all of these things, more and more of us are doing our banking and investments and so forth online. But if something happens to you and your power of attorney or your personal representative needs to come in and take over and make sure the bills get paid, that the lights stay on, that the heaters stay heating, if they don't know where you have accounts and where they can lay their hands on money to take care of you and or your estate, then they're really hamstrung. So with this smart book, I know this sounds dangerous, but you really need to have your user IDs and passwords, because there's no magic. Just because I have a power of attorney doesn't mean I'm going to be able to do anything for you if I don't even know where you bank, if I don't even know what bills are paid automatically and what are not. So you trust somebody enough to make them your personal representative and to make them your power of attorney. You need to trust them enough to make sure that they have access to what they need to do to take care of you and to take care of your family. Also, something very important for people to know is, who is my primary care physician? Once again, if something happens, your family needs to be able to know who to contact, and that's name and telephone number and email address if you can get it, because time is of the essence. And then make sure that if you do have a safety deposit box, that the important people, your fiduciaries, know where it is, what institution it's with, that they have a key if they need a key, and that the institution knows that they are to have access to it, that they have authority to it. And then life insurance policies, another thing to put in your smart box. Believe it or not, the life insurance companies don't read the obituaries and say, oh, Morgan, oh, we've got a big policy on him. Let's call up his widow and tell her she's just hit the jackpot. Doesn't work that way. If you have life insurance policies, you need to make sure that your family knows about them, that they have copies of the policy, that they know who the broker is, so they know who to notify in the event of your either injury or your incapacity or your death. So again, have that smart book, make sure the right people know where to look. Okay, bonus tip, ask questions while the price is right. And maybe I'll go back to.
There are some additional questions that came in after you went through, if you want to take a look.
I'm not sure.
Can you have two people on a durable medical power of attorney? I think that's where you left off. That was a question that came in after the average price for probate.
Can you have two people on a durable medical power of attorney? Oh, yes. I will usually go 2 and maybe 3 deep. So again, in my case, to make it easy, my wife is number 1. My daughter, who is a doctor herself, she is an emergency room physician, would be number 2. And then I would have a third, or a second child would be the third. But you don't want to have them be joint. You do want to have them be individual. Let's see. Um, Yeah, safe harbor trust, that they're asking about this now, and I'm competing with Google. So the Medicaid, typically, as Medicaid, if you are the surviving spouse, you don't have an obligation to give anything to your spouse other than the maximum or the minimum that the probate laws provide for. And so what somebody's asking is, safe harbor trust is a testamentary trust created by a deceased spouse for the benefit of the surviving spouse. The assets are treated as available to the Medicaid applicant only to the extent that the trustee has an obligation to pay for the applicant's support. Doing Medicaid planning for nearly all of us is something that you've got the tail wagging the dog, because Medicaid limits what can be used. That's what a special needs trust is sometimes about. And you can also create a trust, which doesn't necessarily be a testamentary trust, but let's suppose that you are the uncle of a child with cystic fibrosis, who is 100% disabled and receiving supplemental security, and you do not want to disqualify them for that. You can create a special needs trust. It looks to me like a safe harbor trust is very much the same sort of a thing. Now, the fact of the matter is that there is no member of my family that I want to be living off of Medicaid, off of a little less than $800 a month, plus certain medical benefits and so forth. Unless you have an extremely unusual situation, it makes more sense to plan for disability and to have ways to pay for it, which is somewhat better than putting them in a Medicaid bed, because fewer and fewer organizations, nursing homes, skilled care, assisted living, want to have a Medicaid patient. And that's just a reality. And that's a long way of saying I have done Medicaid planning, but it is the exception and not the rule. Okay.
Did you see the other two questions? How long should you get a long-term care policy for? 4 years
I
question?
didn't see that one.
It just says, how long should you get a long-term care policy for? 4 years question?
A long-term care policy is one of those things where, again, I can't give general advice because I really need to know about your situation as to whether or not a long-term care policy makes sense. Bear in mind that a long-term care policy is an insurance policy that need never be paid. You may never get a nickel from a long-term care policy. So it's not like a life insurance policy or something like that, where you are assured that there will be at least some distribution, some payoff at your passing. So many people can be self-insured on a long-term care policy. They are expensive. There is what amounts to a deductible. It's called the exclusion zone. There's a lot of complexity to it. In some people's cases, it makes sense, particularly if there is a family history of dementia. But again, that's so personal and it's so specific that I don't want to give you any broad terms as to what's advisable.
The next question is, please discuss the perils of HIPAA on the medical POA chart.
Yeah, the perils of HIPAA. Oh, well, that's what I was talking about
Yeah.
the woman that didn't know that she was married anymore. And nobody would tell the husband that she was there. Luckily, the police that were involved finally was able to just find out where she lived, and they ended up reunited, so it was a happy ending. But the Health Insurance Portability and Accountability Act is also what amounts to the Medical Privacy Act. And that's why you need to have a medical power of attorney, because without it, you can't help take care of your loved one's medical affairs. And that's why power of attorney is necessary. Because power of attorney specifically talks to that. There's another aspect to that too, and that's that you have a chicken and egg problem on the financial power of attorney, because the financial power of attorney only comes into effect if you're disabled. And how are you supposed to be able to get a doctor to certify that if the doctor won't talk to you because of HIPAA? Good powers of attorney will actually take both of those situations into account and will specifically give the person, the agency, the HIPAA waiver that they require.
And there's another one here. It says, how about an asset protection trust used?
That's out of my bailiwick.
Okay.
There are people that do that. I would say that asset protection trust is for extreme high-end earners. And I do mean extreme.
Are there any other questions or comments that you would like to direct to Skip? Now's the time. That was perfect timing, Skip. You got us all the way up to 5:30. This will be recorded and on our website for the future. If anyone wanted to review the information today, and then Skip will also be presenting for our fall retirement session, which will be on, Skip's presentation will be September 20th. Let's see. When do you need to have a lawyer look up or update your will?
When things change, I actually had a will that I probated that had, the record for me was a will that was done in 1968. So
Wow.
at that time, the children were minors. They had appointed a personal representative who was long since passed. And truth to tell, it would have been much better if nobody had ever found that will. So if you appoint somebody as your personal representative, you appoint somebody as a power of attorney, and that person passes away, goes to work for the Peace Corps in Zimbabwe, that's the time to change it.
Ah, okay. Remember the survey, folks. It will be, Jessica, is it going to be out tomorrow or tonight? Probably tomorrow, right?
Tomorrow.
Okay, so take a look at that, and remember, if you want to be entered into the drawing for the gift card, let us know on that survey, and we will do it.
Somebody asked if they could get a copy of the slides.
I think, isn't that one of the handouts, Jessica? Didn't you give us, you gave us the PowerPoint. Is that something you want out or not, Skip?
No, I don't have any problem with that.
We'll
Okay,
get it onto with the rest of the handouts, as well as the survey and everything out tomorrow morning.
okay. And you all saw the website or the link to get the handouts, which is at our website, ppacg.org/events. And then I think there's a state after that, a state. Is that
Jessica
right?
just added it to the chat, Pamela, so it's all set
Yeah.
in there for people to access.
Oh, excellent. I guess it would help if I looked at the chat. Thank you, Jessica.
Okay.
Okay, Did you have
Thank you,
anything you
everybody.
wanted to add, Bree? Oh, I'm sorry. Go ahead.
No, I didn't have to, just thank you, everybody, for your attention.
Oh, okay.
No, we just want to
Yes.
thank Skip on behalf of N. Thank you so much for the great presentation. It sounds like everyone in the chat really enjoyed it. And we thank all of you for joining us and participating and getting this great information. We hope that you have a wonderful evening.
And I'll second that. Thank you all for attending, and we hope to see you next week, next Monday, for our presentation.